going to be cause 24002598. And this is Brian Clarence Bland versus David's Family Pizza. All right, do I have someone here on behalf of the plaintiff, Brian Bland?
Hi, good afternoon.
Good afternoon, sir. Thank you for being with us. All right, and on behalf of the defendant, David's Family Pizza LLC?
David Brenner, Your Honor.
Good afternoon. And Mr. Brenner, are you counsel?
Yeah, I am. Yes.
Just make sure.
I'm sorry.
I was just making certain.
Okay, thank you.
All right, and Mr. Brenner, we're here on defendant's motion, correct?
That's correct, Your Honor. We filed a traditional motion for summary judgment on this case.
All right, go ahead and tell me the reasons that defendant is seeking disposition now.
Thank you. Mr. Bland filed a claim, a tort claim, arising out of an injury that he sustained at work. Armed robbery took place. He and another employee actually defended the place, apprehended the assailant until police came. He was taken away. In the course of doing that, he injured his shoulder. He filed a claim for workers' comp benefits. He's receiving workers' comp benefits. Davis Family Pizza is covered under workers' comp. Under Texas law, when you have a work-related injury, which he had in the course and scope of his employment, which he was, the exclusive remedy is workers' comp. You may now pursue a tort claim. So in our motion, we attached evidence that the claim was filed, and that's Exhibit A, and benefits were initiated. We also attached a copy of the workers' comp policy to show that that was a subscriber. Under the Supreme Court precedent, the two standards to meet are, one, that the person was an employee in the course and scope, and two, that there was coverage, and then the exclusive remedy applies, and the court really has no room to hear a tort claim because there's no tort benefits recoverable.
All right. Mr. Bland, have you reviewed the defendant's motion?
Yes, Your Honor. Can you hear me?
Yes, I can. All right, and how would you respond to defendant's motion that you have exclusive remedies through workers' comp?
Your Honor, I don't believe that is true. The workers' compensation was for my shoulder. It had nothing to do with the mental health and also the financial loss that I suffered whenever I was misled about the workers' comp. I didn't receive any benefits for approximately 4.5 weeks, and that was due to the owners purposefully and almost unlawfully, possibly unlawfully, steering me away from the workers' comp, saying there was no help available, and the state would have to help me. And I have proof of all that as well.
All right. I think what I hear is the real flood of your defense is that you're not seeking this judgment you're not suing. The lawsuit is not about your shoulder injury. It's about mental health.
Yes, ma'am. And the damages.
Mr. Bland, does the mental health claim stem from your work there at the defendant's place?
Yes, Your Honor.
How do you distinguish that as not being a claim related to your work?
Well, the part was because I didn't get the workers' comp benefits, and I suffered financial hardship and loss because of that.
Did you apply for workers' compensation benefits for your mental health?
Well, yes, yes, Your Honor. But initially, what I'm saying is what happened was I didn't receive my workers' compensation in total for my shoulder or for the mental health, and that was because the defendant steered me away from that, and that's what I was seeking. That's what I was seeking compensation for on top of the injuries that I sustained.
I want to be clear. You applied for benefits through workers' comp for the same thing you're suing about now. I'm going to read your petition and let's see what you actually said your lawsuit is about. And that'll help me out because people sometimes change it after we get into it. But I am aware that workers' comp is an exclusive remedy. So if your damages that you're seeking arose out of your work environment, defense motion is going to be valid and I'm going to grant it. That's why I'm asking you, is your claim related to your work with the defendants, or is it completely unrelated to your employment there?
It's related to my employment there, Your Honor.
Okay. Then, Mr. Bland, my reading of the statute and in reviewing defendant's petition is that you would have an exclusive remedy because it was from your work and your work has workers' compensation insurance. It's only when you've exhausted those remedies that you can seek relief from another court.
Sure, and I did not know that. I do have one question. In
Absolutely.
regards to what happened with the benefits for workers' comp and me filing for them and the defendant steering me away from them, the financial hardship that I suffered, and I do have proof of that as well, am I not, can my case not be heard for what happened in that regard? Because I had so much that happened. I was without pay for a month because of what the defendant did behind this case.
All of those things stem from the worker's claim. Your loss of income due to inability to work and the PTSD arising from that all still falls within the worker's comp. But here's what I can give you, Mr. Bland. Today, I'm going to grant the defendant's motion for its summary disposition in small claims court. No worries about the distinction, y'all. We'll grant the defendant's motion, which means that your case would be dismissed because it is improper to file in our court. We don't have jurisdiction. You have two things, at least. You have at least two things. You have other things you can do, but I will point out two specific things that you can do now, Mr. Bland. One, you can appeal my decision. You have 21 days to appeal my decision. If you don't appeal it, this decision becomes final. So that is something you want to be paying attention to. You've got a little bit of time to appeal, okay? In addition to appealing, it's not one or the other. You can do lots of things. And Mr. Brenner, this is information and not advice, right? I'm saying that these are available, as would be true for anyone. Mr. Bland, all parties can appeal my decision, and Mr. Brenner technically can appeal even though he's won for his client, but we are not a court of record, so both parties have the right for an appeal. Mr. Bland, you can appeal. I would also just say that you may want to go and seek information related to your workers' comp claim, including the things that you were seeking here. I cannot tell you whether or not you have, that is not what we do, but I can say that if you're looking for some free information, two good resources would be the local Travis County Law Library and then the statewide TexasLawHelp.org website.
Thank you very much.
All right, good luck, sir. Again, both parties have 21 days. If not, this judgment does become final. All right, Mr. Brenner, thank you for providing me with the motion and an order. The order does look sufficient, so we'll go ahead and sign that one.
Thank you, Your Honor. Are we
All right, all
excused?
parties are excused. Good luck, everyone.